Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about child abduction. Cases that should have gone to the Supreme Court of Canada, but didn't. And we're talking about child abduction specifically in the family law context, where if a parent from another country abducts a child to Canada or brings a child to Canada without permission from the other parent, there is a process under the Hague Convention to allow that child to be returned to their country. But one case raised a very important issue, which was what happens if a parent removes a child from a country and brings them to Canada and then a refugee claim is filed. Because on the one hand, the Hague Convention is important for returning children to their parents in situations where somebody has, without permission, removed a child from the country in which they were originally living. But on the other hand, refugee claims are made by people who would face persecution, who could face serious bodily harm or death if they return to their countries. And the desire to protect children should far outweigh the desire to reunite children with families in situations where those claims are legitimate and real. And it's rare, but it does happen. And it would be important for the Supreme Court of Canada to have heard a case involving the application of the Hague Convention procedures in the context of a refugee claim, where there are these competing interests, both of which are looking at what is in the best interest of the person who's affected, but also both of which are operating under procedures that have relationships to international law as well, or international political and social circumstances. This is not just national importance, which is the test for a case going to the Supreme Court of Canada. This goes one level above it. It's international importance. Canada could be, if the Supreme Court of Canada had heard this case, a guiding post to the rest of the world for the application of the Hague Convention in circumstances involving refugee claims. And yet the Supreme Court of Canada chose not to take this case, despite its obvious significance, not just to the parties, but to so many people across the world. And if the Supreme Court of Canada decided the case in favor of allowing people to stay to carry out the refugee claims, notwithstanding the Hague Convention procedures, then that would give a lot more comfort and guidance to other parents who may feel pressured by the state of the law and pressured by the long arm of the Hague Convention procedures not to remove their children from unsafe circumstances in countries where they could legitimately make a refugee claim, but maybe where the other parent is not supportive of doing so. It's unfortunate the Supreme Court of Canada didn't see all of the significance that comes with this case and take the opportunity to chime in on it. Hopefully it doesn't take another child escaping a dangerous situation in a country with their parent for this case to come before the Supreme Court of Canada again, but unfortunately that's what seems inevitable. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Please like, subscribe, and share with your friends.